For coming to this, the third and final presentation of the Student Scholar Series this year. As you know, the series was instituted 4 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Amy Kokot. Before I introduce Amy, I'll introduce the respondent to her presentation, Bonnie Hannon. Ms. Hannon has been a prosecutor for 21 years at the state level for a number of years before coming to the Department of Justice. She joined the department in 2008 and the Capital Case Unit in 2010, where she remains. She is responsible for litigating federal death penalty cases and participating in the protocol review process of every federal death-eligible case. Prior to joining the department, she prosecuted in such places as the State Attorney's Office in Florida, the District Attorney's Office in Kansas, and the local office of the Attorney General in Washington, D.C., specializing in child abuse cases and violent crime cases, including homicide. Thank her very much for coming today. Now let me introduce our presenter, Amy Kokot. Amy received her B.S. degree in psychology from Mount Holyoke College in 2003. She has been employed at the Department of Justice Civil Division, Torts Branch, since 2004 as a paralegal supervisor, an incoming note and comment editor with the Catholic University Law Review. She'd like to continue to work at the DOJ when she completes her law degree. You heard that, Bonnie? You heard what she said? All right. Amy's interest in her topic was piqued by her Women in the Law seminar taught by Professor Cara Drynan, who nominated Amy's work. She worked with Professor Drynan on a directed research basis, and the article she will present today is a product of that study. I'll now turn the floor over to the third of this year's student scholars, Amy Kokot. The title of her presentation, Prosecutorial Indiscretion, District Attorney's Misuse of Alabama's Chemical Endangerment Law to Criminalize Pregnant Women's Substance Abuse. Amy.
I just want to briefly thank everyone for attending today, and in particular my respondent, Bonnie Hannon, and Professor Drynan for working with me on this project and for her feedback throughout the process, and also to Professor Harmon for coordinating the Student Scholars Program. So first, just a brief roadmap for my presentation. I'll talk briefly about my topic selection, move on to my thesis, and then I'll talk a little bit about the particulars of Alabama's chemical endangerment statute, overview in the plain text, the legislative history, and then recent developments. I'll then move to my thesis that prosecutors are exercising undue discretion, and I'll go over some of the reasons behind these prosecutions. Finally, I'll move to my resolution and ways to counteract this trend, most likely by legislative initiatives, and then I will conclude. So my topic selection, I noticed when I was trying to come up with an idea for this paper, America's fixated on pregnancy just in terms of a recent wave of articles and media attention focusing solely on pregnancy. It's a vehicle to propel struggling actors back into the spotlight with TV shows and books and that sort of thing. So a lot of just media attention around celebrity pregnancies and in general. But alongside this cultural fascination is case law and legal scholarship and stories in the popular media as well concerning attempts to regulate women's conduct during pregnancy. So a couple of examples that have received a lot of press. There was a pregnant woman in Indiana who was charged with murder and attempted feticide for the death of her unborn child following a suicide attempt. And also a pregnant woman in Iowa fell down the stairs, and when hospital staff thought she had done so intentionally because she thought she had considered abortion, she was arrested for attempted feticide. And what piqued my interest in this specific topic is that during my preliminary research, there were just so many cases since Roe v. Wade that discussed attempts to regulate pregnant women's conduct, and there were numerous cases concerning pregnant women's substance abuse and attempts to prosecute under various statutes that govern criminal child abuse, child endangerment, drug delivery, and homicide that have been applied to prosecute women nationwide. So I reviewed the case law and journal articles in my paper, and I won't repeat them here. But one recent example of this trend was Alabama's chemical endangerment statute, which was enacted in 2006 to protect children from methamphetamine labs. But DAs have utilized the code to initiate proceedings against women who ingest drugs during pregnancy. And what was really striking to me was the sheer number of prosecutions, so approximately 70 over the course since 2006. But also, unlike prosecutions in nearly all other states, those in Alabama were upheld. So Alabama is an outlier because the vast majority of state courts have rejected comparable approaches. And that's because social services and related agencies typically handle cases of maternal substance abuse as opposed to law enforcement. So in my initial research on the statute, recent developments and prosecutors' reasons for bringing these cases, that is what led to my thesis. And in my paper, I argued that district attorneys are exercising undue discretion in utilizing Alabama's chemical endangerment law to prosecute women for their drug use during pregnancy. And proceedings contravene the law's plain text and the legislature's clear intent. But Alabama courts have nevertheless upheld women's convictions and, in doing so, prosecutors' misconstruction of the code. So Alabama's chemical endangerment statute, this is the text of it. I highlighted a few words that have been at issue in court decisions. Canons of statutory construction in terms of what is said and what is not said in the plain text. What is not said, pregnancy, uterus, child, unborn child, I'm sorry. And in Alabama, child is defined as a person under 18 years of age. But a lot of the court decisions have turned on the statutory definition of the term child and whether it includes an unborn child. And there's, in addition, the affirmative defense portion of the statute states that it is an affirmative defense to a violation of the section that the controlled substance was provided by lawful prescription for the child and that it was administered to the child in accordance with the prescription instructions provided for the controlled substance. So what struck me about that was typically prescriptions aren't written for unborn children, they're written for children that are born. So taken as a whole, that portion struck me as being inconsistent with prosecutions involving pregnant women and unborn children. So what led to my actual thesis? In terms of the legislative history, I researched the legislative history of the statute, and it was very clear the legislator sought to protect children from explosive methamphetamine laboratories. And the bill's stated purpose was to create the crime of chemical endangerment of exposing a child to a methamphetamine laboratory. And as an example, the first case brought under the law involved two individuals following the death of their infant daughter, and the child died after exposure to methadone in their home. The Alabama legislature never intended for the law to be used to prosecute maternal substance abuse and has declined to amend the law to encompass maternal substance abuse several times. So, for example, in 2008, the debate on whether to expand the statute to apply to unborn children specifically, legislators voiced concern that if the law was revised, women with histories of drug addiction would avoid prenatal care and would seek abortions to avoid prison. And also, attempts to modify the statute show that the code, by its plain language, does not apply to unborn children because if it did, amendments would be unnecessary. So a couple of specific examples of legislative intent. The state senator who sponsored the law in 2008 stated, "I hate to see a young mother put in prison away from her child. And if a mother could be put in a treatment program with her children, that would be the best course. Maybe we need to revisit the legislation." And additional legislators filed an amicus brief in support of the petitioners in two cases that I will discuss momentarily. And the brief reiterated those views that when legislators passed the law, it was never intended to and does not apply to permit the prosecution of women who expose their fetuses to drugs. So now I'll turn to, in terms of what is happening, before I turn to the undue discretion, I'll just highlight a couple of specific cases that have also received a lot of press. As background, Alabama is divided into 41 districts, and a handful have steadily attempted to criminalize pregnant women's substance abuse. And initially, only one DA pursued these cases, but more recently, additional DAs have initiated proceedings as well. And for example, over an 18-month period in 2007 and 2008, 8 women in one jurisdiction of approximately 37,000 people were prosecuted. 37,000 people in the jurisdiction, and 8 women in that jurisdiction. So Tiffany Hitson's case, Hitson was one of the first women who was prosecuted for maternal substance abuse. And in 2006, her newborn tested positive for cocaine and marijuana. And like others involved in similar actions, she didn't want to risk trial, and she spent 1 year in prison. And her successful prosecution influenced proceedings elsewhere in the state, including that of Hope Ancrum, who was prosecuted after she and her son tested positive for cocaine, and the records documented her drug use during pregnancy. She pled guilty to chemical endangerment of a child, and she was sentenced to 3 years imprisonment, which was suspended, but she was placed on probation for 1 year. And finally, Amanda Kimbrough, her son was born prematurely and died shortly thereafter, and Kimbrough tested positive for methamphetamine. The DA charged her with chemical endangerment of a child. She pled guilty and received the minimum 10-year sentence because her case involved a death. And Kimbrough and Ancrum appealed their decisions, which I'll speak about in a minute. Their cases went up to the Alabama Supreme Court. And it's worth noting that both women received widespread support in their appeals. 47 parties signed on to the amicus brief, including national and Alabama healthcare providers, drug policy organizations, human rights organizations, and addiction experts. And the brief argued that these prosecutions and those to come will deter women from seeking prenatal care and from sharing concerns with medical providers, thus endangering fetal health by incarcerating women down the road as well. So why is this happening? Prosecutorial discretion is a fixed component of our criminal justice system, and prosecutors enjoy autonomy because legislators and courts rarely attempt to interfere with discretion in the charging function. But DAs may misconstrue legislative intent in their exercise of discretion. The realization of legislative intent depends on the decisions of those in the executive and judicial branches. And proceedings under Alabama's chemical endangerment law exemplify DA's misconstruction of legislative intent in their exercise of prosecutorial discretion. So what has gone wrong in Alabama? Why is this happening, and why does it continue to happen? I came across a few reasons. DA's personal beliefs. DAs genuinely believe that they are preventing substance abuse by pursuing these cases. They believe that the law guarantees children a safe environment and a drug-free environment, even in utero, and that they're trying to salvage lives because they have an affirmative duty to help the child and to help the mother. And DAs also believe that a viable fetus is included in the term child, as used in the statute, and is unambiguous, which is in line with courts' interpretations as well, but contradicts legislative intent. DAs' political careers, DAs have an agenda based on my research. They have personal and political agendas. For example, one DA was running for district judge, and his campaign emphasized his prosecutions under the law, and including advertisements featuring doctors praising his decision to have women serve jail time if they were found to have abused drugs during their pregnancy. So in all likelihood, his stance on maternal drug use contributed to his political success. DAs have been encouraged by their superiors. They've been praised for their efforts. To recognize one DA's work in this area, the Alabama DAs Association, as well as the Alabama DA Investigators Association, named him DA of the Year in 2009. And finally, these prosecutions have been sanctioned by the state's courts, including the state's highest courts, and, as I said, the Alabama Supreme Court, which I'll get to now. Prosecutors were holding off on bringing cases to some degree until the rulings, because these cases have been pending for a few years, but now they feel that they are authorized to move forward. So DAs who are anxious to take a stand against conduct that risks harm to the fetus or to the newborn are able to more freely pursue cases. And so given that the judicial and executive branches have authorized these proceedings, which are in line with the DA's personal and political agendas, but in contravention of the statute's text and the legislator's intent, it's a bit of a perfect storm. I want to depart a little bit from my paper now to talk about the Alabama Supreme Court decision, which issued in January of 2013. And this decision was the Ancrum and Kimbrough cases, which were consolidated. and they were cases of first impression before the Alabama Supreme Court. The issue on appeal was whether the chemical endangerment statute governed the women's conduct, and the court found that it did. And I just want to flag a few aspects of that decision for discussion. The court devoted a significant portion of its decision to whether the word child as used in the statute includes an unborn child. And the court did refer to canons of construction and examined the statute's plain meaning and said words must be given their natural, plain, ordinary, and commonly understood meaning. The court did acknowledge that the state conceded the statute does not define child, but argues that an unborn child is a person. The court also acknowledged that the fundamental rule of statutory construction is to ascertain and give effect to the legislature's intent in enacting the statute, and to do so, if possible, by relying on the language of the statute itself. But even with that said, the court held that the plain definition of child is unambiguous and broad enough to encompass unborn children. And because the court found that the word child was unambiguous, the rule of lenity did not apply. And finally, the court stressed that Alabama's policy is to protect born and unborn children, and the Alabama Attorney General praised the decision as a landmark victory and stated that the court has ratified our argument that the public policy of our state is to protect both the born and the unborn. There is a little bit of departure in the conclusion. The court basically invited the legislature to come in and amend the statute if it disagreed with the reasoning. And I think it's worth just reading that, because after pages of the court defining child as unborn child and providing reasons for that, it did point blank invite the legislature to come back and amend the statute. It said, "We would be remiss if we failed to recognize that the legislature may disagree with the result of this court's interpretation and application of the chemical endangerment statute, and is free to amend the statute to effect a different scope for its application." Now I'll just talk a little bit about why the decision was flawed. The court's application of the word child is inconsistent with legislative intent. And as I discussed earlier, the legislative intent is clear. The plain meaning of the word child as used in the statute applies to children who have been born and who could be exposed to drug paraphernalia or to places where drugs are made or sold. And for cases in which the legislature meant for laws to apply to unborn children, it used clear and unequivocal language, such as fetus or unborn child, as opposed to just the more broad term of child. And it's worth noting that the statute was enacted the same year that the legislature amended the state's homicide statute to specifically define person to include an unborn child. So they did it in other circumstances, but not here in the same year that this law was enacted. And read as a whole, the statute does not include certain terms. As I said, fetus, pregnant women, or womb. The legislature selected each word deliberately and purposely excluded certain terms as well. And the affirmative defense provision, again, that a controlled substance was lawfully prescribed to the child. Plain meaning of the word child there would suggest that it's a child who is not in utero, but one who can be given medication. And just an aside, to talk about ambiguity briefly, the court's conclusion that the term child is unambiguous. In my paper, I argued that the term child was unambiguous in the other direction. I'm a little bit more inclined now to say that it is ambiguous, just based on the decision itself, that it was 6 judges on the majority and 2 dissented. So within that decision, there are competing definitions. But even if the term is ambiguous, the result should be the same, because basically, if the term is ambiguous, then the rule of lenity applies. So the statute, as a criminal statute, must be construed in women's favor. And as support for that, the court in the majority states, "It is possible to conclude, as petitioners argue, that the legislature understood the original chemical endangerment statute to protect only children who are already born. It is also possible to conclude, as the state argues, that the legislature understood the statute to protect born and unborn children." And finally, in terms of policy, the court did say that the state's policy is to protect born and unborn children, but a competing interest, the state has a legitimate interest in protecting children as well. But the statute is not the means. The competing and equally important state interest is protecting the health of women and not discouraging prenatal care or not discouraging women from being honest with their medical providers for fear of arrest or prosecution. And these interests are undermined and not advanced by expansion of the law. Pregnant women would be deterred from even pursuing drug treatment if they feared arrest. And protecting children is not accomplished via criminal charges and prison time. Deterrence is ineffective. And finally, expanding the law could potentially encourage women to terminate their pregnancies if they feared arrest. As I said, there were two dissents, and both underscored the lenity principle, and that criminal statutes must provide clear notice of what is prohibited. And they both criticized the majority for acknowledging the rule, but nevertheless construing the term child as broadly as possible. And the dissents also said that the majority's construction will encourage those who have violated the statute to terminate their pregnancies. The majority's conclusion does not reflect the legislature's intent or canons of construction. And it is possible to conclude, as petitioners argue, that the legislature understood the original chemical endangerment statute to protect only children who are already born. So again, the dissents say that if there is that ambiguity, by definition, lenity applies and the criminal statute must be construed in women's favor. So proposed solutions to thwarting this trend. My initial paper was completed just before the decision came out, and in the paper I'd argued that the court should come down the other way and send a strong message to prosecutors, but to deter this behavior and end the competing definitions. But I also argued that, preventing such actions through executive actions proves challenging because DAs have been sanctioned for their work in this area and praised publicly for their stance on maternal substance abuse. But also, legislative initiatives could lead to reform practices. In line with the Alabama Supreme Court's conclusion and invitation, they invited action if the legislature disagreed with the result of the court's interpretation and application of the statute. So since the legislature has confirmed that the statute does not apply to pregnant women, their substance abuse, or their unborn children, DAs and judges have not construed the law to adhere to its purpose, and textual modifications would resolve these competing interpretations. And to facilitate this process, NGOs, including the 47 parties that were on the brief, the ACLU, the American Medical Women's Association, and other organizations that support Ancrum and Kimbrough could lobby the legislature to amend the law. And these groups could continue their advocacy by attending hearings and requesting meetings with the legislature, members of whom would likely be amenable to these meetings, given that they have publicly stated that the law goes against their intent. And also, these decisions have set Alabama apart from nearly all other jurisdictions, making it the only other state besides South Carolina to uphold such prosecutions. And in so doing, there's been media attention and newspaper articles, and NGOs could build on that coverage and continue raising public awareness through outreach and maybe even social media campaigns in this age, but to garner support from those who oppose the prosecutions. And legislative intervention as well by providing written criteria for charging decisions. The state legislatures have enacted laws that contain recommended guidelines and commentary in other states with the goal of establishing predetermined and objective criteria to advance impartiality in prosecutorial decision-making. And such codes address the evidentiary sufficiency necessary for decisions to prosecute and make plain that prosecutors may decline to prosecute in situations where prosecution would serve no public purpose, would defeat the underlying purpose of the law in question, or would result in decreased respect for the law. And the Alabama legislature could enact comparable laws that set forth written criteria on charging decisions. So conclusion and implication, Alabama's chemical endangerment statute was never meant to criminalize maternal substance abuse, but DAs have not construed the law to adhere to its intent. They have misconstrued the law to prosecute pregnant women for their substance abuse, and to date, Alabama courts have upheld these convictions and thus prosecutors' misapplication of the code. So the implication of these rulings could affect states other than Alabama and women beyond its borders. because if left unchallenged, Alabama's chemical endangerment law and prosecutors' application of it could potentially serve as a model for similar legislation and could even become more accepted nationwide. Such proceedings might also provide a bridge to further regulation of women's conduct during pregnancy. But at this point, legislative actions could counteract unchecked prosecutorial discretion here and confirm that the law was never intended to apply to maternal drug use.
Sure. Thank you for your presentation, Amy. You and I chatted just before the presentation today and offline a couple weeks ago about some of the questions that I had regarding your premise. And I guess it's twofold. I would ask, now in light of the recent Alabama Supreme Court's ruling, do you think, would you still frame the issue in terms of a prosecutor's discretion to charge or a legislature's decision to, amend a statute, or the court's decision to uphold the statute? Because are we now talking about a situation where prosecutors, were found to have upheld the law? I mean, legally they certainly didn't do anything wrong. Some would argue ethically they didn't, and it certainly seems like the public policy in Alabama and elsewhere is that they did it. So I'm curious if you would now think about, or if you have thought about reframing the issue, switching the emphasis from prosecutors to the court and to the legislature. And then the second question I have is, and we talked about this, do you think that it's ever appropriate for prosecutors and law enforcement to address the kind of behavior at issue here, which is harm to the fetus through substance abuse? Is the issue specifically with this one particular statute, or is it broader in that you don't think that law enforcement should ever regulate a woman's conduct during pregnancy? So is it really an issue of the law, this law, or maybe a constitutional issue?
Well, the first part of the question, I think definitely now that the court decisions have come down, that the legislature's role is more important. And I tend to think, I argue that the prosecutor's interpretation and application of the code was so clearly in contravention of the legislature's intent that it was, as you said, ethically questionable. But I think it is up to the legislature now to come in and explicitly say in the law, this code is not meant to apply to maternal substance abuse, to pregnant women, to their drug use, to unborn children. I think that will make it very difficult for these prosecutions to continue. It's a tough call because, as you said, they're not now in contravention of the law. They've been sanctioned by the state's highest court, and they've been sanctioned by their superiors. So 2 of the 3 branches are okay with this. So it is up to the legislature. And I don't think that it becomes less of a prosecutorial discretion issue because it's so clear what the intent was, that these prosecutions, regardless of personal beliefs, are not consistent with the intent.
So let's say that you are, I don't even know if any jurisdiction specifically has a law that addresses prenatal substance abuse by a mother. So let's say that you're in a jurisdiction that does not have a statute that specifically addresses criminalizing the acts of a mother, using substances illegally while pregnant. Mm-hmm. Do you envision, and do you think the public policy supports prosecuting those women under existing laws, recognizing that there are certainly other ways, other than a specific statute to address that problem, but there are other ways that you could address that issue? I mean, do you think that, again, just generally, is this the kind of behavior that you think that we can regulate and should regulate?
I think it has to go back to intent. Almost every other state besides Alabama has, I don't know that every state has seen a similar case, but other states have overturned convictions for cases brought under homicide, child abuse laws, homicide laws, child endangerment laws, laws that pertain to drug transmission via the umbilical cord, and courts have overwhelmingly overturned those convictions. So I don't think that those statutes are the means given that precedent, but at the same time, it goes back to legislative intent. If there is a law that explicitly seeks to criminalize this behavior, if that's the intent, then I would be more inclined to argue that the prosecutions are in line.
And so if there's not a law that specifically addresses this kind of conduct, do you think that it's always unethical for prosecutors to work within whatever laws they have in their jurisdiction to address these issues? And I gave you the hypothetical of this real world sitting in a courtroom. And I guess I should back up by saying we also had this discussion that I know you talked about competing interests in the public policy of protecting children versus women seeking prenatal care. And we talked about how in prosecution, usually when you see these women, you're at the end of the line. Like everything else has failed. By the time a case comes to your doorstep, it's because they didn't get prenatal care. It's because they didn't go to their health care. They didn't do all these things, and now they're sitting in front of you, either on a drug possession, a forgery, a worthless check, something that they've done to violate the law in furtherance of their drug habit. And so under those circumstances, when you've got the visibly pregnant woman tweaking in court, going through methamphetamine withdrawal, sitting on, I don't know, say a worthless check or forgery charge, and I mean, what would you do if you could argue, say, for example, for a no bond, where as normally, on a property case or a nonviolent case, the person would get a bond. Do you think it's okay for a prosecutor to make a decision to argue for a no bond for the health and safety not only of the woman, but as importantly, if not more importantly, the unborn fetus?
It's a tough call. I think that ethically, I can certainly understand that if women would come to you under those circumstances, and if you are the end of the line, so to speak, I think that it has to be consistent with intent. It has to be consistent with application of the law to others, and I don't necessarily know that they can be held without bond, because despite the tragic circumstances, it just might not be the most ethical use of laws that were intended for other purposes.
Well,
such as a check, or to sort of keep them there without bond on a different violation.
So, and typically in that situation, you're looking at like risk of flight and public danger. So, could you make the argument that public danger encompasses a danger to the fetus?
I think it's a more sympathetic or an easier argument to make than Alabama's law. I think that is more broad in terms of a public danger, and it depends on, going back to construction, going back to how terms are defined by the legislature. But I think that would be an easier argument to make if it's a public. But that said, I don't know that that's despite being at the end of the line, I don't know that that's the best course to keep women in jail to further prevent substance abuse.
So then it sounds to me like then you could never envision a situation where it would be proper to prosecute under the law. Because even if you had a law that specifically addressed substance abuse, while a woman was pregnant, it sounds to me like even under those circumstances, if it specifically addressed that you still don't feel that would be a proper prosecution, or I guess law?
Well, I think if the intent goes to that, that's different. If the text and the intent go to that, that's different. It's probably arguably not the best to have a pregnant woman or a woman who recently gave birth in jail away from her child or without receiving the proper care. But I think if the law explicitly says what its purpose is, then that's distinguishable.
And then how would you square that then with your argument about the competing interests with, not going after, if you specifically go after then, as opposed to taking it on a case-by-case basis and exercising prosecutorial discretion, if you specifically go after that particular woman, then how do you square that with the competing interest of her not receiving, being afraid to receive prenatal care?
Well, then if it's in the statute, the state's interest to protect the unborn child is more clear. It's in there, and they are competing. It's tough because, as I said, I don't know that there are any circumstances in which jail time would advance maternal health or the health of newborn children. But in a perfect world, primary intervention and reform policies. But seeing as that's probably not, it's pretty far down the road. It's tough. But I think it would be much easier to push at the interest of the unborn child if the text is clear despite the competing interest over it.
Could you see a situation where jail time might be appropriate and advance not only the mother's interest but the unborn fetus's interest if, again, we're talking end of the line? It's either that or you might just OD on the street and, kill your, harm your fetus, harm yourself. Again, because again, I look at this as, from a prosecutor's standpoint, is we're not generally going out on the street looking for cases. I think I explained this earlier. Like, we're up to our eyeballs usually in allocators with cases that we can, barely keep hold of, and we're certainly not looking for more. So when stuff comes to us, it's because usually everything else has failed, and now you've got a problem just staring you in the face, looking at this pregnant woman, or like in the Alabama cases, child dies 19 minutes after childbirth, and you say, what do I do? And so so that's why I keep coming back to it. Is it that you can never envision that, and isn't that contrary to public policy about protecting kids?
I can envision it, but I also, to the extent, jail isn't perfect either. There are drugs within jail. There are very good reasons that prison time is not going to help the women. Chances are, if they're at that point, they might be able to find ways to continue their habits within jail to further endanger their unborn child in jail. I don't know that I could never envision a situation like that. It's hard for me to think of one. But I do think that jail, in theory, might keep women off the streets and keep them from that final OD. There are also arguments to be made that it wouldn't.
So we agree, because we talked about this beforehand too. This is not a constitutional issue in terms of women always have a right to do what they want with their bodies, during pregnancy.
It depends on the jurisdiction in the text and what they're doing and the balancing of the public policy and versus that. Yeah.
Questions from the audience?
So I enjoyed your presentation. I have a couple of comments. The first is that I do think there are situations I can envision where going to jail might be the best thing, especially for an unborn fetus. So I know of situations where that's the only way a mother was able to get clean was being in jail. I'm not saying it's perfect, but I think that's different than, I would imagine you would consider that differently if a child had already been born.
Potentially, although I don't know the statistics, but maybe for every child that might come out all right in jail, there might be another one who doesn't. So in terms of the numbers on that, and
I'm just saying I think those two situations are different, so I would address them differently in your paper. And then my other comment is that in terms of where to go with the paper, I would think that I don't know anything about the Alabama legislature, but it seems unlikely that the Alabama legislature is going to come and overrule the Supreme Court. So maybe asking the Alabama, or arguing that the Alabama legislature should give guidance to prosecutors about which cases to pursue and what sort of questions to ask, that might be useful. And I also agree with your point that you made at the end about the implications that the Supreme Court decision might have with respect to other jurisdictions. So
I do think,
like
though,
from a reader's perspective, that would be an interesting place to go with.
Thank you. Yeah, and I do think, though, that the fact that the court invited legislative action might incline the legislature to be more likely to come in and step in, and because there are legislators on the record saying that this is not what they intended, so they might be more inclined, given that last paragraph of the decision.
Maybe, except, again, I don't know anything about Alabama and the legislature, but
Yeah.
if it would be a very unpopular decision, then the legislature might be unlikely to do that.
It's an uphill battle.
And I also enjoyed your presentation. And I have a suggestion too. You seem very focused strictly on legislative intent, which I think is important. But public policy, is a broader. Public policy comes about in a lot of different ways, as I'm sure you're aware. And so the one thing I did think of when you were talking was this decision came out in January. I don't know about the Alabama legislature, but I suspect they probably have just gone through or are very close to the end of a legislative session. And if they were interested in taking up the Supreme Court on its invitation, it probably would have happened this session. I mean, if there was any, if they were just really incensed about what's been going on in these cases. So you might want to look into a little bit about, what happened this session, if it was even attempted to have been brought up. And if not, this could really be public policy making by inaction. And so you might want to consider that. Thank you.
Steve, include both of them.
There seems to be, I may be wrong, but there seems to be an assumption in the court opinions that the way that a fetus metabolizes drugs or chemicals is the same as a child. And is there anything that you saw in your literature review that sort of addresses this thing that yes, they are the same? Chemical entanglement for a fetus is identical to the same as to a child, or has the science shown that in fact it's very different?
Science has shown, I can speak more to, the science has shown that cocaine, methamphetamine, those long-term effects are much more unknown and not confirmed, excuse me, than alcohol and tobacco, which I found interesting. Whereas you have fetal alcohol syndrome and low birth weight from tobacco, there's no syndrome or definitive syndrome stemming from cocaine, from marijuana, from those sorts of hard drugs. So that I found interesting because there's not a whole lot of medical science to support the outcome for children who are exposed to that in utero.
Did your courts address this at all, or did they leave that?
They left it open for the most part, but the amicus briefs did address it, and that's in part where the American Medical Association and those organizations came in to say that there's no conclusive evidence that there's even harm that's, the tobacco and alcohol is confirmed, whereas this is much more of a gray area.
To what extent is this case or this issue a stalking horse for abortion? The reason I ask is I can see people who are opposed to any kind of regulation about women's conduct because that's a wedge issue that can be justified. After all, if we can make it a crime to expose a fetus to illicit substances, why shouldn't we be able to make it a crime to allow a woman to destroy a fetus by abortion? On the other hand, is that what prosecutors are trying to do, or is that what the people who are opposed to such prosecutions are afraid are going to happen? Is that an issue that you address?
I didn't address it specifically. I think it's part of the DA's agenda is to limit or to sort of chip away at abortion rights, at women's rights to terminate a pregnancy. I didn't specifically address it in my paper. I think it might be worth addressing given the recent state laws that have come into play in the last 6 weeks.
I mean, it might at least be worth mentioning as a footnote as something that may be under the surface, rather, because you can expand the paper into something very different if you're
right.
into that. But acknowledging that may be an undercurrent might be worthwhile.
But can I follow up on that? I mean, I think that's a tough argument to make. I mean, I think you'd be hard-pressed to say that, one of 200 prosecutors sitting in office, like I said, with, 100 cases on their desk, is looking on a daily basis to set policy on abortion. I mean, you're looking to get through your cases and do the right thing and uphold the laws. I don't really think, especially line DAs, are making any kind of decisions along those lines. And you could really say that about any law on the books. I mean, I was thinking when I read this about, well, what about marijuana? I mean, if marijuana is on the books, then you have an obligation. I mean, you swear an oath to uphold the law. You have an obligation to prosecute those cases that come to you. And, whether somebody's using it for medicinal purposes, if that's not the law in your jurisdiction, or you think it should be changed, again, I kind of come back to, is that really on the prosecutor as opposed to the courts and the legislature?
So maybe this is just something to think about for paper number 2, right, as you continue your scholarly career. But I think there are actually a number of examples where you might explore the tension between criminal law and the abortion question. And I know you didn't tackle the abortion question in this paper, and so close question is good to think about forward-looking. But we just talked about a case in my criminal law class that dealt with defense of others, where a woman argued not just self-defense, but defense of others because she was pregnant. And one of the things that we discussed in class is the students were raising the fact that she could argue defense of others, and then under the law, the very next day, abort her unborn fetus, lawfully so. And the tension of that. And so there might be, I guess what I'm saying is that there might be ample other paper in the ways in which there are tensions between the Roe issues and some of these criminal law dynamics.
Yeah.
Mary?
I was just going to say, I do think you have the wrong target in your sites, as the prosecutors, as our evil commentator mentioned. And I think an aspect of that is, coupled with Beverly's question, if your paper takes the position that the legislature's been given backslap by the court, but the legislature hasn't acted as though they've received that. So I do think that that calls into question your thesis, and it's not fair to you that it does. We've all experienced the court decision 2 weeks before our paper goes to print. So, but I would suggest refocusing, but the other aspect of that refocusing is, why won't the legislature act? Well, one thing you touched on in the beginning, but as I'm sure you know from your research, Alabama has the worst child protective services system in the country. Maybe Mississippi is worse, but they're 49 and 50. So why aren't they acting? Because their dependency side, that's going to cost some money, and they're going to have to put money into the dependency side in order to deal with this very real problem of the drug-addicted pregnant mother. They need to do that, and then they won't. So what I would say is I think it's a legislative inaction in a couple of arenas that could speak to your concern. And the problem is not, I think, the prosecutors being left saying, well, legislature hasn't fixed this social problem. The community is demanding I do. I represent the community. I'm going to work with the laws that I have. And you know what? The court just told me I won that argument. I was right. There's something to think about.
Thank you.
Well, let me thank Amy for another fantastic presentation.
Thank
and
you,
Bonnie
everyone,
Hannon
for coming.
For helping us responding to the work. Amy, from the faculty here, recognition of your contribution to the Student Scholar Series this year. Thank you all for coming very much.